It's amazing how many twists and turns there have been in the litigation against Illinois' gun and magazine ban that was enacted on January 10th by Governor J.B. Pritzker. And we've been doing everything we can to keep our eyes on all of the moving pieces just on this one law, let alone all of the other lawsuits there are about the firearm owner identification card, about whether or not, you can be your FOID card suspended if you're just arrested for a crime, and that's just in Illinois, let alone all the other lawsuits there are across the country. But we've been looking at the federal cases. We've been looking at the state cases. Of course, we started the show talking about the Illinois Supreme Court denying a motion for two justices to recuse themselves and for the Supreme Court to disqualify those justices. That denial was issued late Friday. But something else Friday, we talked about this Friday morning after seeing attorney Thomas DeVore's video where he talked about the Amicus brief he filed in the Calkins case that's now in front of the Illinois Supreme Court. So I wanted to reach out to DeVore and have him on to talk about both of those issues. Attorney Thomas DeVore, thanks for taking time with us this morning. Let's go ahead and get right on into it with the top news here that these justices denied that motion for recusal. As an attorney, your thoughts?
You know, attorneys try not to weigh into these things too much, Greg, but I will say that first and foremost, the public, and this is not a criticism, it's just an observation because I was the same way before I became a lawyer, they fail to appreciate the politicalness of the judicial system like the other branches of government. I mean, the judiciary has people in it, and people by their nature are political. So, there's more politics in the judicial system as a grand matter than I like to accept, but it's a reality. As far as them not recusing themselves, it wasn't a slam dunk argument. That the motion filed by Mr. Stocks was well written, but it didn't surprise me that they didn't recuse themselves. I would have liked to have seen them to, given the timing. I mean, those big donations were pretty contemporaneous with this election cycle, and that nexus of time I thought was one of the most compelling things, because there's certainly a perception there, at least by those that oppose the gun bill, that could influence their behavior. I'm not here to say that it will or it would. The appearance exists. So I wasn't surprised they didn't recuse themselves, but I thought the argument was well made. And one of the justices, I don't remember which one, kind of took issue with the motion and got a little bit curt in her response to the movement, Mr. Stocks' client. And I thought that was a little inappropriate and wasn't necessary.
And, of course, talked about that earlier, and I think you're referring to Elizabeth Rochford, who made the statement in her denial that, let me see if I can pull this up, plaintiffs cast sinister aspersions that contributions to my campaign committee were made to influence the instant litigation. Plaintiffs provide no factual basis for that, warning that the courts must consider whether attacks on a judge's impartiality are simply subterfuge to circumvent anticipated adverse rulings. So that was part of Elizabeth Rochford's.
And that would lack professionalism saying that. I mean, and no facts. Mr. Stocks in his motion didn't accuse anybody. He said the appearance all along, which is certainly appropriate. So the fact that the justice took it upon herself to write that in that tone, again, to me as an attorney, when I read that, I'm taking that more of her offense that she was putting out there gave more merit to Mr. Stocks' motion and not less. So it was unfortunate that she chose to do that, in my opinion.
Attorney Thomas DeVore with us. He is somebody who is well known in challenging the state's laws. When we had, of course, the mask mandates and all of that, you remember him following through and getting all those cases put together. You've got 3 other cases challenging the gun ban, temporary restraining orders, keeping thousands of named plaintiffs safe from this being enforced. Those are temporary, though, Tom. What's next in your case? Where we're heading in the trajectory of possibly advancing forward?
Well, we have a hearing on May 4th as it relates to discovery. Interesting enough, Greg, the legislature passed this law, as you're well aware, because you follow it as well as anyone in the media, completely behind the scenes, behind the doors, backdoor deals, etc. None of it's in the public record. And so the public can't really appreciate what happened and how they passed that law. So when I started issuing discovery requests, the state defendants are now objecting, saying they have immunity and they don't have to give us anything. Chief Judge Jarman was not enamored with that. We have a full hearing on it on May 4th, and I'm very confident that he's going to insist that they turn over the information that I'm asking for, because otherwise the public has no idea what they're doing. And on top of that, Greg, some of the lobbyists and like the Illinois Association of Chief Police, Illinois Sheriff's Association, these are lobbyists, not government actors. They're even objecting, saying they shouldn't have to turn over to the people the communications between these lobbyist organizations and these legislatures in the passage of this law. And I don't think the judge is going to stand for it, but they're suggesting they don't have any obligation to disclose what they were talking to our legislators about in the backdoor stuff. And it's really unfortunate. So
a little over 2 weeks, we'll definitely look for you to get us an update on what happens in that hearing with your 3 cases. But back to the Macon County case, you've had some back and forth with the Calkins case and your case and which one's better and whatnot, and even had criticism for Calkins advancing his case to the Illinois Supreme Court. But all that aside, you filed on Friday a friend of the court brief with the Macon County case. Tell us about this.
Sure. And as it relates to the Macon County case, again, it's not about better or worse. It's always been about taking the absolute best case to the Supreme Court on this issue because of the reasons you see in the way that recusal denial was written. You've got to take the best case. We don't have the best case there now, but the case is not horrible. I read the motion or the brief that Mr. Stocks filed on behalf of the Calkins matter. Pretty well written with what we have to date. I saw the amici brief filed by 33 states attorneys, and I filed one as well on behalf of my clients as it relates to the 3 readings rule, Greg, because the court can uphold the judgment finding this law unconstitutional on any legal reason in the record. It doesn't have to be based solely on equal protection. And so I raised for the court the obvious issue of the 3 readings rule, which has been violated blatantly and openly, where, the lawyers for the Attorney General and the governor said so much in our hearing on the 18th of January, yeah, we know we didn't follow it. There's nothing the court can do about it. So I've asked them to consider that as another reason, kind of like the amici of the state's attorneys asking that Second Amendment be applied. And so, Mr. Stocks did a good job in filing his brief. Again, he doesn't have any facts in there should the court, drop the burden to rational basis and that lower standard of review. But I even made the argument that if they were to go there, which I don't know how they ever could, but, you always have to assume the worst, that they need to send the case back to Macon County for further proceedings and not just give the governor a quick win, which is what the governor's looking for.
Attorney Thomas DeVore, greatly appreciate your time. As always, we'll definitely connect soon in the weeks ahead as we continue to track what happens here with the litigation against Illinois' gun and magazine ban. Be safe, all right?
Yes, sir. Thank you. You too.
Springfield's Morning News on WMA.